I'm just gonna press record and let everyone in.
Good
Hello,
afternoon.
Mr. Kelly.
Hi, this is John Kelly from Strelo Court Reporting.
Yes, hi, how are you today?
I'm fine, and yourself?
I'm good. Mr. Kelly, is there anything you need from me or the board, names or anything like that in order to proceed?
So far as I know, no, I am in possession of the scheduled hearing report.
Okay.
And-
So far the order looks like we'll do case number 5, 6, 1, and then 3. And then Nancy Cameradiner is our chair and board members are Dominique Ward, Paula Weiss, and George Matthews. Adriana, hi, how are you today? And Miss Angela Brockington Long, how are you today?
I'm good, thank you. Hello.
All right. Adriana, is this your witness, the person from the iPhone?
Yes.
Or witness? Okay, great.
My name is Lamont Jones, not
Thank you,
person.
Mr. Jones. I'm gonna put you on mute because you're probably not gonna need to talk right now, okay?
No problem.
Thank you. And Ms. Baker and Mrs. Peng, I think they work at the law department, is that correct?
Yes. Mr. Peng is a new attorney.
Great. All right. I think we are ready to start. And I'm gonna press record. And wait, there's something in the chat. Okay. We can proceed. Well, apparently we were recording anyway. Hi, everyone. My name is Melissa Andre. I'm the Executive Director of the Tax Review Board. And today we are convening a session today, Tuesday, October 4th. It is of 2022. It is approximately 2:03, and we are doing water hearings. Please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy. By continuing to be in the meeting, you are consenting to being recorded. At this time, I'll give over control of the board to our chair, Nancy Cameradiner. And Nancy, take it away.
Okay, fine. Thank you very much. Good afternoon. The Tax Review Board hearings for October 4th, 2022 will come to order. Our first item is going to actually be number 5 from the agenda. Benoit Wilkins, last 4 digits of the docket, 2831. The address is 2014 East Chelton. Who has this matter for the city?
I do. Adriana Gonzalez on behalf of the city.
Do we have anyone here for the petitioner?
I don't believe so, but let me just go check.
Okay. Yeah, that was my understanding ahead of time, but I thought I would double check.
No, we do not have anybody.
Okay. Can Ms. Gonzalez, can you tell us what this matter is? We understand there may be a bankruptcy situation here, which is why we were taking it first.
Yes. The petitioner filed for bankruptcy back in 2019 in relation to a sheriff's sale matter. They were attempting to redeem the property. So at the moment, the bankruptcy is still active. There is a plan, a Chapter 13 plan in place stating that they will pay all utilities, including water. And that plan does not contemplate any sort of reduction by any board. Additionally, they do not currently own the property. Redemption is also stayed for the bankruptcy.
So does this, the board have any jurisdiction on anything here, or does that mean that we really have to put this matter aside?
I mean, at the very least, I would ask this not be denied for failure to appear.
Should this be withdrawn by the petitioner if they've entered into a bankruptcy agreement to pay? Or no action needed by the board if we get documentation to that effect?
Yeah, can you provide with the bankruptcy plan? Because then I think we could do no action needed.
I do have the bankruptcy plan. I apologize that I did not attach it to the previous.
Great. So I think the board, based on the information, if we get it from Adriana, Ms. Gonzalez, I apologize. We should find this no action needed.
I will forward this.
Could we do that contingent on receiving and reviewing the documentation? So it doesn't have to come up again?
Sure. Once she
Is the
gets.
city in agreement that we mark this as no action needed then?
Yes, yes, the city is in agreement with, I mean, I think
I mean,
while
where,
no action needed is a possibility. I think one of the first places with the board can reach is that the petitioner failed to appear. Regardless of any bankruptcy issue, they are not here to allege that their bankruptcy is in any state other than
Okay. Well,
What
how
is
about we
currently
just
before us?
hold out
have
and
we spoken? Did the petitioner know they needed to show up today? Has the city spoken to the petitioner and let them know that they needed to show up today? I'm just trying to understand what happened. Did we get any of that testimony on the record?
the
no.
city has not spoken with the petitioner. And I do not, given that this is the petitioner's action and they have likely asked that it be stayed pending the bankruptcy, I would not have assumed any responsibility to inform them of whether or not they should show up, especially not as their counsel.
Well, let me back it up a minute. Ms. Andre, do we have anything from them for this hearing, from the petitioner, or are they just a complete no-show?
Yeah.
What I have is multiple things that say stay from chapter 13 bankruptcy, like constant bankruptcy. The last time we listed this was June of 2021, still under bankruptcy, continued. So I don't know if we received that information from the petitioner or from the city, but perhaps we just put this one on hold until the end and then make a determination if the person comes, and if not, then we can just simply mark this as a failure to appear,
Okay,
regardless of.
Okay, so then we'll reserve judgment on this until at the end of our agenda.
Correct.
Okay.
And I have
that-
just sent Ms. Andre the bankruptcy confirmed plan and the bankruptcy docket.
All right, I'm gonna forward that to the board, but for right now, we're gonna go to case number 6. I'm just gonna put them in the room.
Let me identify case number 6 while she's getting the petitioner. It's Q Yun, last 4 digits of the docket 1781. The property address is 2321 Garrett Street.
Yes, please come in. Yes. Oh, of course, you can come in.
Yes,
Of course.
good afternoon.
Okay,
Hold on.
is there someone else coming with you, or are you the only one coming?
No, there's somebody
With
else.
My
Nancy.
husband.
Okay, I thought the way, I could only see half the screen.
Yes.
Now I can see that there are 2 people. Okay, fine. Wait, please identify yourselves for the record.
Yes, my first name YUN, last name is QIU.
And you, sir? Please identify yourself for the record.
My husband, actually, I am the owner.
Okay,
Yes, the only owner.
and will he be testifying or speaking at all?
Oh, yeah, he can,
But that's why I'm asking him to identify himself for the record, so that if he wants to speak later, he is going to be on
okay.
the record.
yes, he tried his best. His English is not as good as mine, yes.
Please identify yourself for the record.
YUE.
My name is Yue Jianli, YUEJIAM. This is my name, my first name. My last name is LI.
Okay, thank you. For both of you, do you swear or affirm to tell the truth with everything that comes before the board?
Yes, we swear. Yes, swear.
Sir?
I swear.
Swear.
Yeah.
I swear.
Okay, fine, thank you. Who has this matter for the city?
Good afternoon, Adriana Gonzalez on behalf of the city.
Do you have anyone with you who may need to be sworn in?
Yes, Ms. Brockington Long and Mr. Lamont Jones.
Okay, if they would identify themselves for the record, please.
My name is Angela Brockington Long, and I'm with the Water Revenue Bureau.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, and the other city witness?
Mr. Jones, you can unmute yourself.
Okay. My name is Lamont Jones.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, thank you. Ms. Brockington, are you the one who has the numbers for us?
I do. Okay, the period in question is June 6, 2016 through January 17, 2019. The principal is $1,204.35, 0 penalty, 0 lien, and the total is $1,204.35.
Okay, thank you. Does the city have any opening comments or should we turn to the petitioner?
Yes, the city does have a few opening comments. I do believe that those amounts are no longer due and owing as a first matter. Secondly, the petitioner no longer owns this property. It was sold to a third party for $230,000 in 2019. Additionally, as my witness will testify to, both witnesses will testify to later, the property was found with no meter with a straight pipe, and a meter was installed in 2019, which is what spurred the back bill.
When was the property sold?
The property was sold, if you give me one moment to bring up the deed. The property was sold March 15th, 2019 to a W. Kong Realty LLC for
Okay,
$233,000.
okay.
Was it as a result of that sale is that when the bill was paid?
Yes, I'm not entirely sure, but that is likely what occurred. If they
Okay,
had title insurance, that that was what would have occurred. Pardon.
Okay. I'm just trying to figure out whether the petitioner has any standing here if the property was sold and paid for and we're now 3 years beyond that time.
So let's ask Nancy whether there's documentation from the new owner giving her authorization or from the title company giving her authorization to continue to pursue this.
Okay. Could you say that as a more direct question for
To
the,
her, yeah, for the petitioner, Ms. Quay? I'm sure, is that how you say, I'm sorry, how do you say your last?
Cho.
This Cho.
Yes.
When the city has told us that this property is no longer yours, is that correct?
Yes.
You don't own it anymore.
No.
So therefore, this bill was paid by the new
No,
owner?
by myself. Before selling, we had to go through everything, so I paid it ahead.
Okay,
Am I-
so however, because you're no longer the owner, the bill is no longer your responsibility, whether paid or unpaid. Unless you have some paperwork from when you sold the property that allows you to continue to represent the property. Was anything done at settlement to allow you to continue to dispute this bill?
No, because we have no idea. When we decided to sell the property, and then they told us we had to pay the bill, and in order to sell our property, that's why we decided we pay all to close our property sale, in order to close it. Yeah.
the time period that you paid for, was that all time that was during your ownership, or did you pay for time that went beyond your ownership?
It's during my ownership.
Then weren't you responsible for paying that amount? Why do you think you need to have some adjudication on this?
Yeah, because we approved our paper approved during this period. We never live in that property. That property is not living condition, because this is a property when we buy it is property, and there was fire before. So that's why we didn't realize that they're missing the middle during this period. So we put our own money to make it new until later inspection, and then they said, "Oh, you don't have the mirror." And that's why we asked someone to come over the department to have the new mirror in there. But later during this period when nobody lived in these properties. Yeah.
But you owned it at the period you're talking about.
Yes, I owned it. I owned it. Yeah.
But
When was the property sold?
March 15th, 2019.
So she filed this petition before she sold the property back in February of 2019.
Correct. Approximately 14 days before the property was settled and sold.
Okay. And so her argument is I paid the bill at settlement and she wants a refund for the bill. And she wants to dispute how much the bill was at this point. That's her posture at this point.
That seems to be the case.
I mean, I don't think you're understanding what we're trying to say, that when you sold the property, since you no longer own it at this time, either the new owner has to give you some type of authorization to seek a refund if you feel like you overpaid for it, or the new owner would have to challenge, I'm guessing, the amount that was paid in.
I think it's nothing to do with the new owner, because my argument is, when we own this property, nobody lives there. So
That doesn't,
we understand that, but we can't even hear that testimony if you don't have authorization to represent the property anymore. It's not your property. You can't be in front of us, or we can't provide any relief for someone who doesn't own the property, because any relief we provide is going to go to the new owner, if we were to provide any.
But we pay before we sold it.
But we understand that, but because the water bill belongs to the property essentially. And so when the property is sold, the water bill, any payments, any refunds, any activity goes with the property to whoever the current owner is, which means that we don't have the authority to provide any relief for a former owner.
We try to reach the new owner. She not responds. We try 1,000 times. We also try to find a seller agency, but unfortunately, we have his email address, but he never responds to us.
do I understand correctly that you actually made the payment to the city before the sale,
Yes, that's correct.
but only days before the sale?
Yeah, before the sale. Otherwise, I couldn't.
That- Anyone looking at that from the outside would think that you were assuming the responsibility for it and that you were indeed the one required to make payment. And I'm struggling to figure out how and why you think that you should not have had that responsibility.
Because she's arguing that that she shouldn't have had to pay the bill, but she wanted to make sure the sale went through. That's what it is. So she reserved her right by filing this petition within the 60 days of getting the bill.
Yeah,
So the sale could go through, and now she's trying to get her money back. So, I mean, it was either she doesn't have the sale happen and she sits here and she waits to get a hearing date, or she pays the bill and now comes based on the letter that she put in her petition, which directed her to do precisely what she did, which was come to the tax review board
Right.
to seek type of some resolution.
okay.
But it's not even in a refund posture,
No.
which it would have
Because at
had
the time she filed the petition, she hadn't paid
been
yet.
paid.
Yeah.
I mean, any relief we provide would go to the new owner.
Do the board members want to step aside, or do you have other questions before we would do that?
I think maybe you guys should step aside.
Step aside.
Yeah.
Just hold on one moment, ma'am, okay?
I have one more question. When
Okay,
you purchased the property, when did you purchase the property?
我们什么时候？2000, a long time ago.
And what did you pay for it? Do you remember?
I pay for in cash by
How much?
around 17,000 or
Thank
8.
you.
Yeah.
That answers my question. Thank you. I'm ready to step aside.
okay.
Everybody just stay put right here. I'm just waiting for Nancy and Paula to get back in the room. Nancy, everyone is back in the room.
There we go. Okay, the board's reached a decision, and it's our decision to deny this petition for lack of standing. You'll get a letter from us that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas. Excuse me, within 30 days of getting our letter. But for the moment, let's assume that you're not going to be appealing to court, nor is the city. And so you would have, I guess really at this point, you've already paid the amount. And so it's just a matter that this would no longer be an outstanding liability or an outstanding effort to get a repayment or refund. Is that, am I stating that correctly?
Yes, Paula Weiss, I concur.
Dominic Ward, I concur.
George Matthews, I concur.
And Nancy Cameron, I concur. Thank you for coming in today. I'm sorry you didn't get the result you were looking for, but we couldn't, after discussing it, feel that we could do anything other than deny the petition. Thank you. You'll get a letter from us probably within 2 weeks, or around that time.
Okay.
Thank you.
Thank you very much.
The next case is case number 1.
May I have a brief moment to let Mr. Jones know that he's excused, and thank him very much for his time?
And that was the only matter he would have been involved in had it continued?
Yes.
Okay, I see no reason why he needs to stay with us unless there's something else you want him to speak about.
No, thank you very much, Mr. Jones. I really
Okay,
appreciate it.
Okay, no problem. See you later, all right?
Thank you. Bye-bye.
Bye.
Okay, we're going now to case number 1, which is DeLuca Aldo and Danielle Aldo. Last four digits of the docket 0714. The property address is 133 Unit B West, and it's cut off on my copy. What is the street address?
It's 133 Laurel Street.
Okay, thank you. Please identify yourself for the record.
Aldo DeLuca.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you. Who has this matter for the city?
Good afternoon, Adriana Gonzalez on behalf of the city.
Okay, and do you have anyone who will be speaking from your end who hasn't already been sworn from earlier cases?
No.
Okay, fine. Do you want Ms. Gonzalez to give us the numbers?
Yes, I'd have Ms. Brockington Long.
Okay, thank you.
Okay, the period in question is October 15, 2016 to September 28, 2017, and March 30th, 2019 through January 6th, 2020. Principal amount, $6,535.88. Penalty, $196.46. Lien, $192, and total $7,325.24.
Could you repeat the penalty amount?
Oh, sure, excuse me. $596.46.
Thank you.
Mhm.
Okay, does the city have any opening comments?
No.
Okay, so then we'll turn to the petitioner. Please tell us why you're here and what it is you're looking for from this board.
I'm very confused why I'm here. I was here August 9th, 2021. So those dates that were just mentioned have already been settled. I've got the settlement sheet here. It was settled at $4,381.31. August 12th, I was supposedly mailed a letter to set up the payment plan by Nicole Davey. She sent it to the wrong address. I did get a hold of her, all my effort, not the city's. We discussed it, and I've already been paying, I think, consistently over $100 a month, which was more than the suggested payment amount, which was $85. And this has been going on since August of 21. Nobody said anything. I've sent FedEx letters asking for something in writing to agree to the payment terms that I was told.
Have you met with the master, which would be a one-person hearing, or with this full board?
I went to municipal court first, and then they told me, this was all during COVID delays and this and that. So then they asked me to come here. So I was actually here before as well. This has already been settled. I have the letters from you. And I've been paying more than the amount of what the payments you guys requested. And then for some reason, after more than a year, I was notified, I got a letter here, you guys can see it if you want, saying we need to set up a payment plan. So of course I called and I tried to contact everybody. And I said, I've already been paying, and I've sent letters, and I've got I've got names written galore, phone numbers, letters, trying to get something in writing. Anyway, I do have something in writing now, agreeing to a payment plan, but it's got the wrong balance because you guys are not deducting from the agreed $43.81 from August of 21. You've added fees and all kinds of other things because for some reason that's got lost in the shuffle with you guys.
Well, let's see if we can straighten that out for you. Ms. Gonzalez, could you please explain to us, where this stands in terms of a payment agreement and a settlement?
I mean, the master abated 100% of penalties in August of 2021. If the petitioner agreed to that and it agrees to that, that is something that my office can definitively fix and make sure works out with the payment agreement terms that he would like to go forward with.
Are you seeing payments? He's making payments. Is that showing up on the account correctly?
Yes, there have been payments made recently. The last payment, as far as our system goes, I believe was September 14th. Another payment may have been made since then, but I have, that may be.
So Ms. Andre,
consistent since last year.
Okay, let's see if we can straighten this out. Ms. Andre, we have a master's decision from August of 21. Is that correct?
Yes, hold on. A minute. I just needed to go. I need to go get the file. There was no vote sheet.
Okay, what I was going to say is what this board can do to facilitate this is reaffirm that decision.
Was there ever an agreement signed with the city in accordance with that decision?
Ms. Brockington Long, is there an active payment agreement in our system and basis?
Okay, let's see. Actually, no, there's there was a most recent payment agreement beginning August 10th, 2022, and was supposed to end March 7th, 2023, but that has been canceled.
23.
That's right.
It can't be 23.
Well, the payment agreement would end.
Oh, that's when it would end.
Yes.
Okay, I'm sorry.
Right, so let's see what we can do here. Ms. Andre?
Yeah, there was a decision from August 12th of 2021 that abated 100% of the penalty charges from 10/15 of 2016 to January 2nd of 2020.
So we can reaffirm that
Absolutely.
and then issue a new decision letter even that reaffirms that decision so that the parties can go forward with the payment agreement as, you know, as this petitioner has been attempting to do, it sounds like, because Mr. DeLuca has made efforts to do and made payments towards. I don't know what my fellow board members think.
I guess I have one question for the city, and that is whether, if we would do that, would the petitioner be paying under terms and conditions that the city accepts? Because we're basically affirming a decision made by the master. And I just want to make sure that the city is in concurrence with our decision to do that.
The city has no objection to this decision,
Okay.
And would recommend that the petitioner bring his letter to the law department directly in the municipal services building, or to call the law department directly to set up the payment agreement with that letter.
You mean the new letter that's coming, or the one?
Yeah. What we're suggesting is that the board reaffirm the decision that was made by our master X months ago, and that we ask that it be recognized so that you can take that to the city and that you would get an actual approved document in terms of your agreement with the city. I don't know whether there's anything.
I have one other question. Because the city is not acknowledging a formal payment agreement, although he's been making payments, have any additional fees or penalties been
Exactly.
on
That's
this?
my concern.
There are additional penalties that have accrued on the account. If the board were to abate penalties at this point, again, the city does not object to that. And the payment agreement going forward would reflect that, and penalties would not continue to accrue so long as the payment agreement was adhered to.
So there are additional penalties on that specific period of time, or rolling forward because of the delinquency?
Ms. Brockington Long might be able to speak to exactly what those penalties apply to, but from my recollection, the last time I looked at the account, there were roughly $300 in penalties. But
the settlement was for 4,381, so it's obviously lower now. And there's different amounts being sent to me. You know, the latest one's over 7,000. This one, which is a payment agreement of $85 a month, says 5,012. I mean, it's just bouncing all over the place.
So,
and when you were making this,
it sounds like to me you need an accounting. So can the city provide an accounting based on what the original settled agreement, a settlement amount that he got from the masters back in August of 2021, based on the payments he's been making, and go forth from there? The fact of the matter is he should only be paying the agreed amount that he got an adjudication for back in August of 2021.
That's my concern as well, that he not be paying or he not have money that he paid already be credited for interest and penalty, which he shouldn't have been charged.
Exactly.
Right. Yes, that can be rectified even through the board making the decision to reaffirm or eliminate penalties.
So that we could say that any previously charged interest and penalty should be reversed.
For the period in question, correct.
For the period in question. Okay. All right. Any other questions either for the petitioner or for the city before we step aside?
Is the period in question from the settlement date forward?
The period in question is the same period in question, which is
August.
October 15th of 2016 to what looks like January 15th.
I don't want to pay extra fees from August when that agreement was made.
Yes,
Well, that's what we're talking about. That's what we're asking about.
Okay.
Yeah.
we want to make sure that all penalties that have accrued since 2016 be removed from your account.
Okay, thank you.
And then an account
Sorry.
can be done on your account, all the payments that you made, all the bills that were made, and then whatever is left will be your settlement.
Okay, and then I'm sorry, and then just for my education, so, you know, whatever, there was never a paper agreement for the payments I made up till whatever recently, but then I did get one, but you're saying it was, after it started, it was declined. Is there a reason why? I just don't want it to happen again. So I don't know why it's declined. I've been making consistent payments, more than the required amount.
I'm not sure who you made the agreement with, so without going back into our, so this is a situation which I would really recommend that the petitioner sit down with a member of the law department who works for the WRB to fully rectify the account.
Okay.
How does he do that?
So
Who would that be? I guess.
he could reach out to me and we can make an appointment with one of our water CCRs in order to get that done.
So why don't you give him your direct email?
Sure. Sir, if you can see on my screen, my email address is my first name, period, my last name. So Adriana, period, Gonzalez at Phila, PHILA.gov.
So again-
You say Doc Gonzalez?
Yes, that is correct.
So again, for this decision, I just want to be very specific. We're going to be abating penalties, and we're going to be abating penalties ever since 2015. I just want to make sure that we abate we remove all these penalties so that any payments you may have made that could have been applied to the penalties not be applied to the penalties. Does
Be
that make sense?
reversed. That all payments may be applied to principal only.
Yeah, I think I want to say something else.
Yeah, so can we then get on an order that an accounting is due to the petitioner within 45 days of this hearing? We can put this on hold versus adjudicating it. So at least there's an accounting that's provided. He knows to come back, we relist this, and at that point, he gets in a payment agreement with the city, and we just make sure it's all neatly tied. It seems like the petitioner has had a bit of a go of trying to get this resolved, and the fact that he's here today, we should really be a little bit more pragmatic about making sure that this is actually done.
Okay.
Let's put that in our
Yeah.
in our decision or our notes, that we know that when this comes back, that our intention is to abate all penalties that have accrued for this period of time, to reaffirm the decision of the master, to ensure that all payments have been properly credited to principal only, August of 2021.
And if this gets done before we relist this case, all the petitioner has to do is withdraw this case.
Exactly.
But we want to ensure that the city does finally make good on the agreement for the.
All right, so Mr. DeLuca, what we're just saying then is when we're going to ask all of these things occur outside of this hearing. You will get another letter for a hearing to be sure that they've been done. If in fact, when you get that letter, everything is fine, the agreement is signed, all of these things have happened, you don't need to come back. You can simply withdraw the petition and let us know that that the settlement agreement has been concluded.
And if
So just from my understanding, I won't do anything until I get a letter. Once I get a letter, then Ms. Gonzalez and I can make the law.
Yes.
Okay.
But within 45 days, you should have an accounting from the city telling you what actually is due and owing, because that's what you do need in front of you to know how much the amount is that you're paying in.
Right. Of course, I'll bring my accounting to match it.
I just asked that the letter reflect that our liens will not be expunged to principal and liens.
Well, I don't know if the liens were put on the on it after the master level hearing.
Yeah, are there liens that were accruing from 2021? Your witness can tell us that, yes or no.
I don't think I had liens before this.
Because the liens are what, $192? Where did they accrue from? Do they accrue after his ruling back in 2021? Then no, they should be removed because you all should have gotten into an agreement with him. We had an adjudication at that time.
I mean, we wouldn't be here if the petitioner hadn't asked for a rehearing.
I've been the one.
He had a master's hearing. He got an adjudication. The city did not work with him to abide by the ruling that he got. That's not his fault. So does he have the $192 worth of liens from that 2021 ruling that he got for the masters?
When were they imposed?
Yeah, when were they imposed? Your witness can answer that question.
Well, there was
When were the liens put on the account?
there's a lien listed on January 1, 2022.
Anything earlier than that?
And
Yes, I'm just
what
checking.
period does that lien cover?
doesn't say the period. It doesn't say the period.
We could abate the lien charges.
Okay. And I'm just looking for prior. I see one 7/1/2020.
The debt collection pathway doesn't tell us what
No,
period.
it doesn't, yeah, when you click in, it doesn't tell you, the period. No. Just the amount. So, you may go back further than July 2020?
There were only 2 liens on the account.
Okay. That's
All right, so we're going to continue this case for 45 days for the petitioner to get an accounting of his payments and with the reversing of the penalties and get himself into an agreement. If in fact he does get himself into an agreement, he does not have to show for the next hearing, just contact the office to withdraw the petition. However, if this falls apart again, please keep that hearing, please come and we can resolve this issue.
It should not fall apart again.
Okay, do we have I have concurrence from all of the board members?
How about the lien? Are we removing the lien also?
Yes, I would
Okay.
at least remove the lien from 2022.
The lien
Okay.
charge from, yeah, that was January of 2022.
George Matthews, I concur.
Paula Weiss, I concur.
Dominic Ward, I concur.
Nancy Camerodiner, I concur. Thank you very much for coming in today. I look forward to hearing that everything's been taken care of and you've been able to withdraw the petition from this board so that you can go ahead with a clean slate on your payment plan.
That's the goal. Thank you so much.
Thank you.
Bye, everyone.
Bye now. I believe we have item number 3 on our agenda as well.
correct.
That's Joe Thompson, last 4 digits of the docket 2455. The property address is 2535 North Natrona.
Is that you, sir?
No.
No. This is J&J Real Estate Investments.
Oh, I'm sorry. I thought we were doing number 3. We're doing number 4 then? Okay. My apologies, because I was told that our next case number was going to be number 3.
I apologize.
Yeah, we thought it was 3.
And it's 4. So I was introducing the wrong case. Case number 4 is J&J Real Estate Investment. Last 4 digits of the docket 0492. Property address here is 4813 North 8th Street. Please identify yourself for the record.
How you doing? My name is Jerome Jones.
Can you speak a little bit louder?
How you doing? My name is Jerome Jones.
Okay, and do you swear or affirm to tell the truth with everything that comes before the board?
Yes,
And your relationship to J&J Real Estate
owner.
owner? Okay. Who has this matter for the city?
Yes, Adriana Gonzalez on behalf of the city.
Okay. Do you have the same party who was already sworn in terms of any additional information, or do you have someone else who needs to be introduced?
No, I have this, Miss Brockington Long is still the same witness.
Okay, then if we could get the numbers for the record, please.
Okay, the period in question is December 23rd, 2015 through July 30th, 2019. Principal amount, $8,534.43, 0 penalty, 0 lien, and the total $8,534.43.
Okay, is there anything else we should know before we turn back to the petitioner?
I believe so. I'm not entirely sure. My unfortunately basis is not connecting for me on my end. But I will ask Ms. Brockington Long, is the petitioner still the owner of the property?
Okay, yes, J&J Realty, yes.
Okay, thank you. That's
Okay, should we turn to the petitioner then, or do you have anything else you want to present to the board before we do that?
No, I have nothing further.
Okay, then let's turn to the petitioner. Please tell us why you're here and what it is you're looking for from this board.
I'm here,
And please speak into the mic as much as you can. I know that's an awkward thing sometimes in these setups, but it would help us to hear you.
okay, I'm here and I see the last bill, or the value they said was $8,534.43. The last bill that I got, I think the bill was $4,000 and $4,500, somewhere $4,500. I'm not sure about the $8,534.43, but that was an estimated reading from the paperwork that I have that the city sent to me, and I think that the reading was off, the estimate. Far as from October 8th, 2019, and moving on from probably to this day, the bill was $66.99, or around $65 to $70. So I think that $8,534 was just a little bit too much of an estimated reading.
Does the
So
city
I'm-
have any questions to cross-examine this witness?
Yes. Is this a rental property, sir?
Yes.
Who lives in the property?
Right now is Aisha Hutchison.
And is that, how many people live in the property?
I think Aisha and 2 people, so total of 3.
And how many units are in the property?
1.
Have you ever had a plumber look at the property during the period in question?
No.
Who's responsible for handling the water and sewer bills of the property?
I am.
And during the period in question from 2015 to 2019, did you read each bill?
No, the bills, pretty much all our bills are automated. So no, I did not physically read that bill.
So you never found it odd that the property wasn't billed for usage during that period of time?
Again, it was a period of time where no one was in the building. From 2015, from when we bought it, and I forget the first tenant that moved in there was August. So it was like a period of time where it wasn't even no water being used.
So just a couple of months.
Correct. So for us to get a bill for $27, it was, or $30 with the use that it was, no one was there taking a shower, no one was there using the building.
Are you currently receiving a homestead exemption for real estate taxes at this property?
Possibly.
Do you live in the property?
No.
Are you aware that homestead exemptions are only for owner occupied premises?
Yes. We talking about water, we talking about homestead.
Do you have any rental licenses for the property?
Yes.
When did those rental licenses, when were those issued?
I'm not sure, but every year we renewed a rental license.
Okay. I have no further questions for the petitioner.
I have some questions. So, Mr. Jones, you purchased this property in 2014, is that correct? Is that what you testified to?
No, December 29th, 2015. That's what the recorded deed said.
2015. And when did you get your first tenant?
I want to say August of 2016.
And how many tenants did you have at the time?
1.
One tenant. And you've testified that there were times when the property was vacant, other than between December of 2015 and August to 2016. When was it vacant?
It was vacant from December to August. And then when we got our first tenant in there, so from hold up. I think from March 2018. March 28, I think March 2018, one tenant had moved out. And then from March 2018 to December 2018, it was empty.
And it's been tenant occupied since that time.
Correct.
Okay. Ms. Gonzalez, can I ask you a question about the bill in question? Is all of it from the period following Mr. Jones' purchase, or is any of it from prior to his purchase?
All of the billing is from the date of Mr. Jones' purchase. I do have one additional question for Mr. Jones that I have, that I hadn't asked, if I may.
Sure.
Mr. Jones, do you have any other utility bills from the periods that you claim are vacant, or a vacant property license for any of those times?
No. No, not with me.
All right, so in looking at the account history, Ms. Gonzalez, that I don't know that Mr. Jones can see, but that was provided to us, it looks like an ERT was replaced almost immediately following his purchase. Is that correct?
So I would very much like to turn to my witness, who will lay all of the timeline out.
Oh, okay.
Okay, thank you.
Good afternoon, Ms. Brockington Long. Have you had an opportunity to review this water customer's account?
Yes, I have.
What type of property is this?
This is a residential property.
Who's the owner of the property?
J&J Real Estate Investment LLC.
And when did they purchase the property?
December 23rd, 2015.
How do you know?
Their name is listed on the deed.
What charges appeared on the customer's bill for the period in question?
For the period in question, it's service and stormwater charges.
Did technicians go out to the property around this time?
They did
When?
on July 30th, 2019,
Why?
due to zero usage.
What did they do?
They changed the ERT.
And what was the result?
The account was back billed due to 54 months of zero usage.
Was the rebilling based on actual or estimated usage?
It was based on an actual reading taken on July 30th, 2019.
So there were no estimated usage charges during that period at all?
No.
And what was that rebilling? How many months? You said the billing covered 54 months. What was that rebilling for?
It was rebuilt. What do you mean? It was rebuilt for zero due to zero usage.
Okay. And did the amount charged to the petitioner take into account previous payments made for service and stormwater?
Yes, it was only for usage. Yes.
Prior to the petitioner's ownership, was there ever any replacement of the meter at all? Or any other?
Ownership?
Well, it never, never mind, strike that. That's not relevant to this period of time. So was the meter ever replaced at any point during the petitioner's ownership? Prior to July?
No.
Okay. And when did the zero usage? Yeah, and the period of time that the petitioner is charged for is only the period during their ownership, correct?
Yes.
Thank you. I have no further questions for Ms. Brockington Long.
I do, and I don't know if Mr. Jones, first of all, does Mr. Jones have this document? Have the account history?
Yeah, I have the account history.
Okay. So can we look at the dates, January 30th, 2015, which is there twice, and then July 30th, 2019, which is also there twice. Okay, so the first line says the ERT was replaced. Correct? Everybody
Yes.
looking at what I'm looking at? It has a meter reading of 184,400. On that same date, it says start reading, and it's got a meter reading of 117,200. I don't understand the discrepancy there. We move on to July 30th, 2019. There's a meter reading of 235,300, and right below it, a meter reading of 113,500. Could you explain those numbers to me?
Well, oh,
Go ahead. I'm sorry. Go ahead.
okay, well, I'm looking at the July 2019. Okay, so that July 30th, 2019 is when they changed the ERT. Okay, so that was an actual reading that they were able to obtain at the time because the ERT wasn't working.
I understand that.
Which is, caused the zero usage. When they came and changed the ERT, they were able to get an actual reading from the meter.
Okay.
Hence the 2353. That's the final read. And the 1135 would be the start read. On the
Of
new,
a different meter? Is that?
well, same meter, but different ERT.
So it was, the meter was reset at that point?
Yes, they did reset because to see the last initial change from M to P 047, that's the meter number. And the last three digits are the P25. Great. But they actually changed the ERT. See, the whole ERT number is different, ending in 9635.
Ms. Brockington Long, could you share your screen? I believe that you
Oh,
are.
sure,
reading
I'm
for
sorry,
somebody
yeah,
else.
because I'm reading from the account, yeah. Okay, give me just a second.
What you're talking about now isn't on the document that I
I'm sorry,
have.
yeah, I'm actually looking at bases, I apologize. Okay, can you see do you get my screen?
Yes.
Okay, I'm sorry. What I was talking about was, okay, going to the date, July 30th, 2019, 2353, that's the final read. That's the actual reading that the Water Department was actually able to pull when they changed the ERT. So here's the ERT number here. So it's a brand new ERT, but if you can see here, the last three digits are M25 changing to P25. That's the upgrade on the meter. So the meter wasn't changed, it was upgraded, but they did change the ERT. So this 1135, that's the start, that's the new reading on the new ERT.
And so that was a new starting point.
Yes.
And I thought the numbers come from the meter, not the ERT, that the ERT is the transmitter.
Right. Well, when they did read, now I can't go too far.
No, go ahead.
No, they do reset. They reset the meter. But it's not a new meter.
Was that due to the upgrade?
Yes, that is due to the upgrade.
So normally, if the meter had not been upgraded, the numbers would have just continued.
I don't know. I'm not exactly.
I'm not going to speak to that.
The Water Department, yeah.
Suppose that your testimony today, the ERT was replaced back in January 2015, and then it was replaced again in July of 2019.
That's correct. And yes, and that's prior to the customer's ownership. Yes.
Okay, so when the ERT was replaced in 2015, you had a reading, you had zero consumption from 2015 to 2019.
Yes.
Okay, and then you installed a new ERT in July of 2019.
That's correct.
Okay. And so the monthly average during that time is the 2187.
Right, that's the implied average.
Okay.
Go back to what we're looking at now on the screen. I'm sorry, Dominique. It says 1181.
Yep.
I'm sorry, where do you want me to go? Oh, here, yeah, this was the final, yes, that was the amount of usage that they were able to pull. It actually covered all the way back to January 30th, 2015, when they changed the ERT at that time.
And the water customer would be responsible for that because they inherited the property, the water bill, correct?
Even though the ERT was changed back then, it wasn't recording or it wasn't presented for bills in all that time. Is that correct?
Well, they received bills, but there wasn't any usage didn't pick up. See, no, there was no usage even after that meter change.
But the meter reading stayed the same from
Right,
1/30/2015
yes. Until
until you got to 2019, and that's when the cumulative amount was 1181.
that's correct.
Whereas it's restated on the other document, 118,100 being the consumption. Does the city have any other questions for the petitioner?
I have no further questions for the petitioner, and at their leave, I'd like them to give a brief closing to summarize.
I have one more question. Before the ERT was changed in January 2015, did you have any readings before that?
Well, you see here, it was, yeah, actually the high usage here, and then it decreased a couple months prior to the year change.
I guess the question I'm trying to ask is, do you believe that the amount of usage that you have cited on July 2019 actually represents that 54 months, or would it be a longer period of time? Because the ERT that was installed in January of 2015 clearly wasn't working either. So that's why I'm asking the question, do we feel like that 54 months, it represents 54 months, or is it longer than 54 months that amount of usage or consumption was used over? If you can't answer the question, that's fine. I'm just trying to figure out if that 54 months is correct, because that does seem quite high for a monthly average in comparison to when we actually have actual usage beginning in 2019, circling around 800 to 500 units of consumption.
Yes, but if you notice here also in 2014, it's the same amount of high usage.
Okay.
Let's come back to the petitioner. Do you have anything to add that you haven't covered or that we haven't asked about?
Just that it was stated that it was an actual bill, and the paperwork that was sent to me stated that it was an estimated reading. Also, it was saying an estimated reading from 1/30/15 to 7/30/19. And as we stated, we purchased the property in December of 2015. So just, we didn't bill from January, but we didn't purchase the property to the end of that year. That's pretty much it.
Mr. Jones, when you purchased the property, you testified that you didn't have a tenant for about 8 months, correct?
Yes, and I have the.
And is that during the time that the property was not tenant occupied, were you doing renovations to it or repairing things?
Just in and out, painting. I think this was one of my second or third properties. So, with me working and me, doing little odds and then things at the house to get it ready for a tenant.
Well,
did you have any plumbing work done?
No.
Thank you.
Did you or anyone else inspect the plumbing in the house during those times that you were working there and you didn't have someone actually living there?
Yes, we inspected it, and, make sure the toilets, make sure, the toilet, everything was, functioning,
So you didn't find any leaks or anything like that when you were working in the property?
None, no.
How frequently was someone there in that time period that it wasn't really being occupied?
Maybe once a week, just popping in if we, if I was over there doing some cleaning or, putting thoughts together.
I do have one additional question for the petitioner.
Okay.
When you purchased the property, did you have title insurance?
That's something I'm not 100% sure. I would have to double check that.
Did you have an inspection done of the property?
No, we didn't have an inspection done.
Was that a no?
Yes, no, no.
I saw a head shake, but I didn't hear
No,
anything.
I'm sorry. No, we didn't. You know, like I said, it was a,
And the stenographer can't pick up a head shake.
I'm sorry.
Okay. Anything else you'd like to add before we step aside to consider a decision?
Yes, if I may.
Yes.
So it is clear from the petitioner's testimony that the property was occupied during the majority of the period this rebilling covers. And their rental license also, if it runs from 2016 forward, and again, the petitioner testified that people were in and out of the property, even testing the plumbing, testing the pipes, even during the time that the property was not occupied. Furthermore, the petitioner has not, other than testimony, has not put forth any information or documentation that would support the claim that the property was completely unoccupied during that period of time. There's no vacant property license. There are no electricity bills, no gas bills, nothing of the sort. Furthermore, the monthly average reading is in line with previous readings from the property in 2014, when new owners, though the uses may be less now, when new owners come into a new property, they may replace shower heads, toilets, and things of the like, and upgrade things that would significantly reduce water usage and bring water usage from something that may be considered high to something that may be considered more reasonable, as in this case. So the average over the 54 months does make sense in the context of the larger account. Furthermore, the petitioner does acknowledge that they received bills and they did not review them, even when they knew the property was occupied. That it is the petitioner's responsibility, as a property owner's responsibility, to review their bills and to make sure they make sense in context of what was happening at the property. In this case, this petitioner, for months and months and months and years, received the benefit of using water for his tenants for money-making purposes without having to pay for any of that. And the result of that is that the other water customers in the city paid for their water usage during that time. And the city would ask that the board not abate the usage for this property.
Okay. Any other questions from board members, or are you ready to step back?
I'm ready to step back.
Me too.
All right. If everyone
Okay.
can just stay right here, the board will be right back. Just waiting for Nancy to get back. Okay, Nancy, everyone is back.
Okay, thank you. The board's reached a decision. It's our decision to adjust the period from 12/22/15 to 7/30/19 to a monthly average of 1,000 CCF. And even before, there was no penalty and no lien charge, and we would reinforce that.
And make payment arrangements within 30 days.
I was just pausing to see what I covered everything there. You'll get a letter from us that spells out our decision. Both sides do get an opportunity to appeal to the Court of Common Pleas within 30 days of the date of that letter. Assuming that neither side chooses to appeal, you should contact the city in terms of entering into payment arrangements for that period so that there's no gap in your coverage time. You'll get that letter from us within about 2 weeks, might be a little longer with the mails as they are today, but you should have that soon, and be sure to follow up on it as quickly as you can afterwards so that there aren't any questions about what might be due and outstanding.
Paula Weiss, I concur.
Dominic Ford, I concur.
George Matthews, I concur.
And Nancy Cameron, I concur. Thank you very much for coming in today, and hopefully you'll be able to get all of this resolved pretty quickly after the letter exchange takes place.
Okay, thank you.
Thank you for coming in.
All right, have a good one.
You too. All right, so we can go to the top of the list. It is approximately 3:17. There is no one present here at 100 South Broad Street, and there is no one in the present in the Zoom waiting room.
And that would be for items number 3 and
Numbers 2, I think you should just read 2,
2 and was it 3?
2, 3, and 5.
No, 5 was already dealt with. That was the
No,
one
it
that.
wasn't dealt with.
Oh,
We
that's
were
right. We need to come back and touch base on that. My apologies. Item number 3 is Joe Thompson, last 4 digits of the docket 2455. Property address is 2535 North Natrona. Anyone have any information on this from before that could affect our decision? I'm thinking primarily of Melissa there.
This looks like it was, hold on one second. It was represented by an attorney at some point.
Excuse me, Miss Andre, pardon me.
Yeah.
This is the court reporter. I
Oh.
apologize, but your voice is just a little muffled. Is it?
No
possible?
problem. Is this better?
A little bit, thank
A
you.
little bit? Okay, how about now?
That's good.
Okay, I'm sorry. I am having issues. I don't see anything. I have a continuance request from the attorney. And then I have,
There've been no prior hearings? Or was there something at the master's level or nothing at that level either?
I don't have no further to appeal.
Okay, just trying to figure whether we should just deny it for failure to appear or if we needed any further notations on that. How do the board members see that?
Just denied for failure to.
Just denied.
And Dominic Ford concurs with denial for failure to appear.
And did I hear George concur with that as well?
Yes, I
Okay,
concur with that.
and Nancy Cameron, I concur. So that matter is denied for failure to appear. And that leaves us with
Number
which other
2.
case, that
Nancy, number 2.
number 2. Okay. I'm having McBeachener, Friday McBeachener. I'm not sure how to pronounce it. Last 4 digits of the docket 2341. The property address is 5241 Montour Street. Do we have any further information about this matter from the past?
It had a board hearing, a master level hearing. It was appealed. It was previously denied for failure to appear in February of 2022. he requested a rehearing. But he had I'm sorry, I'm gonna say this. He had a hearing in February. He requested a rehearing in January, saying he needed a continuance. And the reason why we found him failure to appear is because we didn't process that continuance request. So I don't think the denied for failure to appear in February should count against him, because he had requested a continuance. But there is no continuance request for today. If that makes any sense.
So a
Okay.
simple denied for failure to appear.
Yes.
But without any further additions to that. Agreement from other members of the board?
I concur. George Matthews.
Dominic Ward concurs.
And Nancy Camerdiner, I concur as well. Let's see, then do we have any, then we had skipped over item number 5 before, and we said we would come back to it at the end if there was any contact from or with the board in reference to that matter. This was item, again, it was item number 5. Wilkins Benoit, last 4 digits of the docket, 2831, property address of 2014 East Chelton. I take it we've had no further contact.
No.
And where did we leave this one before in terms of activity? Has there been turned down on things before in activity, things that would be against the petitioner, or should we just be identifying it as did not appear?
I think we should just identify it as a denied, did not appear.
Okay. Paula Weiss.
I concur with that.
Okay, George Matthews.
I concur with that. Yes.
And Dominique Ward.
Dominic Ward concurs with that as well.
Okay, and Nancy Camerdiner, I concur as well. That covers everything that was on today's agenda, unless I'm forgetting something that was not on the written docket. I see no other additions, and so this being the last item on our agenda, this hearing is adjourned.
Have a good
Thank you,
afternoon, everybody. Bye.
Have a good one.
See you all.
Bye.
Miss Andre?
Yes.
Excuse me, now that we're off the record, I do have a question for you.